The following program was made for viewers like you, not those other mooks. They're a bunch of commie-loving, pimple-headed, Birkenstock-wearing zaraza. But not you. You're beautiful and special. So hit the like and subscribe buttons in ways that display your greatness and well-cultured tastes. The following program is about to begin. Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. First and foremost, got to start with a little hail to the queen. Hail to the queen. All hail, queen of recruitment, Bella Stella. All hail, queen of recruitment, Bella Stella. You can all even hear that in echo there. Who did she bring in? Who did she bring into the fold? Who did she bring in? I gotta give her the war horn, right? I mean, that's what we gotta do. That's what we gotta do. Give a little behind the scenes take as to what we're starting with here. But we'll come back to that soon. Right now, first we have to see who she brought into the fold. Who she brought into the fold. Frazzle says Brian Ogden gifted a membership. Kool-Aid 2008, Mama Rocks, Digger number 007. Hey, Digger, look at that. You're a Digger, and now you're a follower too. JL, Michael Davis, Orion Agap, K-Jab, and Jeremy Alt, all brought into the following, courtesy of Queen of Recruitment, Bella Stella. Welcome to the following. Some of you may know, some of you may not know. I am not the leader of the following, never have been. Everybody say it with me. Joe is not the leader of the following. Definitely not. One of the many things that I'm not. There's a lot of things that I'm not. And one of them is definitely very much not the leader of the following. Not that the following is any kind of cult thing, because it's not that kind of cult type of cult. It's not. It's just not. So anyway, I hope all you issued your gratuities, thank yous, and kudos to Bella Stella. Bring you all in here. Brian, newly gifted. Brian says, hit the like button. I have new shovels. I don't know if that's like an offer or a threat. I don't know what that is. I'm not sure. But either way, he's right. You should probably hit that like button. In case you're wondering, I'm at 98,200, like 1,800 people away. 1,800 away from 100,000. I don't usually hit that out. I don't usually come out with that early. The cartoon guy never comes out this early. This is like really early. But I sort of have like a little bit of a pressure because I'm trying to think to myself, I'm at 900. And tonight is like my 994th upload. And I was like, is it even possible for me to get to 100,000 subs before I hit 1,000 uploads? I don't know. I would have to produce a video that really hits. To get 1,800 in the next six shows. I don't know. Maybe if I did like a special for my 1,000th upload and did like, a 12-hour stream or something like that, maybe then I would cross the threshold. I'm thinking about it. Anyhow, but that's not what you all came here for. None of you came for that. Even though you should be hitting the subscribe because the cartoon just told you to, and cartoons don't lie. Everyone knows that. Cartoons lied to you. How would anyone have didn't we all learn everything we know about gravity from Roadrunner? I mean, they never lie. It's just truth. It's hardcore truth. Some people don't want to face these truths, but they are reality. Let's start off with Alex Jones. Alex Jones had a heck of a weekend. You all know that he was hit with that $1 billion judgment. God knows how much money he purportedly owes by now. Probably over $1.5 billion. He's filed for bankruptcy, which anyone could have told you he would, because there's no way someone can survive with having a $1 billion judgment hanging over their heads. But he's going to file for bankruptcy. That's what you do. That's what you have to do. You really don't have any choice but to file for bankruptcy. They knew that was going to happen. They knew that was going to be part and parcel of this entire thing. That was a major part of this entire thing. Filing for bankruptcy, it's not the end of the world. It's a pain in the neck. It's difficult. It's annoying. A lot of people bounce back strong from filing for bankruptcy, and I have no doubt that this is a man that even filing for bankruptcy is going to be much wealthier. He's going to be in the top 1%, no matter, even if after the 10 minutes after filing for bankruptcy. So I'm not really worried for him, but it is an effort to silence him, and he's not very happy about the situation as he let be known on his own show.
I've been under attack. I've been gaslit. I've had secret federal filings filed on me that I'm committing crimes, referred to the Justice Department, which of course wasn't true. We'd already filed it in federal court months before. They didn't even check this shit. If you're going to frame somebody and lie about them to damn federal court, with the know it's already filed in the damn court, you bastard. So you. And anybody else that tries to go on your you want war, you got it. I told you one more lie, and I was going to do this, all right?
I'm not sure if that was before or after.
Good afternoon, Mr. Tremaine.
Hello.
If that was before or after a different emotional outburst that he had. Well, let's check that one out, because there's a separate one where he didn't come across as belligerent. I don't even know what's happening here, but let's check out what he's doing here. Tom, if you go to tape 2.
Can you muster a war cry?
It's a big joke.
It's not really, though. I mean, it is, but it isn't. It's also inspiring.
My voice will completely go into this, but it's fine. It's my resistance to them. It's a God's transmission. It's a human under attack. We're going to beat these people. I'm not trying to be dramatic here, but it's been a hard fight. These people hate our children.
He's obviously facing a lot of mockery from the left for that one. Should have foreseen. Saw that coming. And I'm certainly not mocking the man. I understand the difficulties he's dealing with, and the pain and frustration he's dealing with there. I didn't really know. I don't know whether those tears are crocodile or genuine, but he definitely. I will say that I happen to appreciate his abilities as a content creator. The guy's a friggin' genius. And he's a very intelligent man. And he's dealing with struggles that he's certainly been dropped upon him more because of who he is than anything he's actually done. So I'm certainly very sympathetic to the struggles that he's going through, because, like I said, bankruptcy is a challenge. It's a challenge. And there's a question as to whether or not this would shut him down. What was going to happen as a result of all this? Well, let's hear from the clown in chief here. Not him. I think this is. I didn't watch this video yet. But I was going to share. I was about to share a link. I was about to share a different video. Not a video. An article from Newsweek of covering this story, and I saw a video there which had a clown. I'm not even sure if this is. I assume this is relevant to the article. That's not working. This is not what I wanted. Yeah, I don't care about this clown. I suppose always talked enough about him. In what was described as an emergency broadcast on Saturday, conspiracy theorist Alex Jones claimed that his far-right news company, InfoWars, far-right, it's so far-right, no one can even see. It's all the way over on the right. It's all the way over here. Far-right news company, InfoWars Studios in Austin, Texas, might be shut down by federal authorities soon. This is going to be InfoWars' last show, because I learned yesterday that they were going to padlock the door and kick us out last night, Jones said while in InfoWars on Saturday. On the same day, Friday, May 31st. What? That's not the same day. That's the day before. What is that? This is Newsweek. On the same day, this is going to be on InfoWars on Saturday. He said this is going to be our last show. On the same day, which was not Saturday, but because this was reported, okay, June 2nd, updated June 3rd. So on Saturday, he says this is going to be our last show. And on the same day, which is Friday, the news outlet published an article saying it might be shut down in 48 hours. Newsweek contacted InfoWars by email on Sunday morning for comment on any of evidence of the alleged attempt to shut down the company's studios. Some people are speculating that it was all made up. Jones said he spotted, quote, guards looking at me weird at the entrance to the InfoWars building. I believe his company was going to be shut down. I went with my instinct and discovered this plan to shut us down, he said after mentioning he questioned the guards about what was happening on Friday night. Quote, I discovered this and a bunch of other stuff that I haven't released yet, he added. He claimed he spent the night at the studios to prevent them from being shut down and threatened to call local police. The InfoWars host said he had all the evidence to prove the alleged attempt to shut down the studios, but did not seem so sure that it would actually be happening himself. Quote, there's a 50% chance this is happening right now, Jones said in a post published on X, formerly Twitter. They want us shut down because in bankruptcy and what was happening, we have a path with the judge to continue on for years. And the judge has signaled that. So different groups involved in the bankruptcy that will be exposed soon have literally made a move to shut this place down and end my show, he added. Jones claimed the deep state was making a move to shut down the InfoWars after allegedly after Donald Trump, who on Thursday was found guilty, blah, blah, blah. We're going to beat these people. I'm not trying to be dramatic, but it's been a hard fight, Jones said. I've been targeted for abuse. I was duped by someone. Federal files in secret have claimed that I'm committing crimes. This was untrue, of course. This may be my final performance. I got support from Marjorie Taylor Greene saying that she stands with Alex. There she is, showing her literally standing with Alex. That's a very literal, I stand with Alex. It's far more literal than most of us can do. I would not be able to say I stand with Alex quite that literally, but I do stand with him overall on most issues that he covers. So I figuratively stand with Alex, far less literal than Marjorie Taylor Greene. So that was what was reported hours ago, days ago, yesterday. It's not that long ago. And today, Alex Jones seems to have gotten at least a temporary reprieve. As Time is reporting, after a weekend in which conspiracy theorist Alex Jones warned that his media company faced an imminent shutdown by federal government because of his bankruptcy case, a judge on Monday allowed Jones to keep operating for the next 2 weeks while deciding whether his assets should be liquidated. Now, I'm just going to point this out to you. I just want to just pause here. I actually tried pulling this filing, see the order from the judge that gives him this 2-week reprieve. I wasn't able to find it in the brief amount of time I allotted to research this, which was basically between 10:27 and 10:31 this evening. So I was not able to find this filing during that 4-minute window. Maybe one of you has access to it. I don't know. But the point I just want to make to you is this: I've done judgment collection. I understand judgment collection. I understand judgment execution. By the way, Texas is one of the 2 most difficult venues in the country to execute a judgment. There are a lot of different avenues of sheltering that Texas allows that few states allow. So it's one of the worst places to try executing a judgment. Not that I've ever tried, but so I've been forewarned. When I say forewarned, I was forewarned about this 10 years ago. So, but putting that aside for a minute, anyone who's trying to execute judgment is looking for a pocket that is liquid and earning. Last thing anyone wants to do, if you're actually trying to execute a judgment, is shut down InfoWars. I mean, how stupid would you have to be? You can only get money from a cow that's producing milk. You don't get money by shoving the cow over a cliff. That's dumb. That's ridiculous. The reason you would shove the cow over the cliff, not to be rude about Alex Jones, I'm simply saying cows produce. They produce milk. You want the milk. That's what you're looking to do, right? That's what you're looking to do if you're executing on a judgment. You want to take from what they're producing. Maybe you can't get all of it, but you want to get as much of it as you can. And the more milk they're producing, the more you can take, the more you can lap up. So every attorney who's ever tried executing a judgment and had an interest in collecting the money has been looking for a pocket that hopefully keeps replenishing in ways that few can, like Alex Jones. So, yeah, you don't want to shove that cow over a cliff and say you can't earn, you can't produce, because that's ridiculous. That's stupid. There is such a thing called replevin, or the different avenues for seizing assets. Yeah, you might want to seize assets and sell them off, but let's face it, whatever money you would get from selling off a ripped apart studio of InfoWars is a joke compared to what you could actually execute on. So that doesn't make no sense. Now, I understand that if he goes through a bankruptcy, depending on the nature of the bankruptcy, not that I'm a bankruptcy attorney, but depending on the nature of it, could be reorganization. It could be that somebody's going to be canceling these debts altogether. I don't know. I would give them a piece of what they have as of right now. I'm simply saying that it doesn't seem to make sense if you're actually interested in money to shut him down. On the other hand, a lot of people in Alex's camp would point out that this was never about the money. This was always about shutting him down. That's all they cared about. That's all they cared about. And I'll tell you this much. If anyone's trying to execute this judgment by shutting down his studio, padlocking and keeping him out of there so you can auction off, what, $30,000 worth of assets that you can maybe get out of it? I mean, seriously, you could probably get that. You could probably seize that in a week's worth of content from his show, if not a day or two of content from his show. So why the heck would you possibly do that? That's the stupidest thing in the world. It doesn't make any sense. It's literally cutting off your own. It's cutting off your own foot, so you can use the blood as like from your foot as like lipstick. Like, even the craziest of women wouldn't do that. That's why would you do that? There's a lot of other ways to skin that cat rather than like permanently maiming yourself. So my point here is that if they are making efforts to shut him down, I don't know if they are. He says he believes that they are. If indeed they are trying to shut him down, and you got only a 2-week reprieve, you sort of need to ask yourself, and I think that chances seem likely he would get more than a 2-week reprieve, because it seems so ridiculous that that this would actually happen. In the sense that if a judge in 2 weeks decides, oh yeah, I'm going to let them dismantle your studio, shut you down, first and foremost, he would just build a new studio. I mean, let's face it, you build a new studio in 10 seconds. And just, he can call it InfoWars. It wouldn't be the same product as the studio he currently has. They're just building a new studio. Like, what is the point? It's the dumbest thing in the world. But supposedly got a 2-week reprieve. Both Jones's company, Free Speech Systems, filed for bankruptcy reorganization after he lost 2 lawsuits and was ordered to pay $1.5 billion to relatives of victims of the 2012 Sandy Hook Elementary School shooting. They sued Jones for calling the shooting that killed 21st graders and 6 educators in Newton, Connecticut a hoax, claiming defamation and infliction of emotional distress. Families have opposed Jones' reorg plans, which that you could have expected they would. On Sunday, they filed an emergency motion to convert Free Speech Systems' bankruptcy reorg into a liquidation, saying Jones has not made progress in showing that he will pay the lawsuit judgments. U.S. bankruptcy judge Christopher Lopez in Houston said Monday that he will address the motion on June 14th, so it's less than 2 weeks, when a decision on whether to liquidate Jones and his company's assets is expected. Jones went on his web and radio show over the weekend with a, quote, emergency broadcast claiming Free Speech Systems, including his InfoWar broadcasts, were going to be shut down at any minute by the federal government and bankruptcy system. That didn't happen, fortunately. That's my editorializing. At one point, he urged his followers to form a human chain around his studio in Austin, Texas to protect it. Which, my God, that would have been great for clicks. Some of Jones' comments came in profanity-laden rants, and Jones appeared to cry at points. There's really no avenue out of this, Jones said on his show Sunday. I'm kind of in a bunker here, and don't worry, I'll come back. The enemy can't help but do this attack. On Saturday, Jones was defiant, saying, at the end of the day, we're going to beat these people. I'm not trying to be dramatic here, but it's been a hard fight. These people hate our children. Broadcast in response to apparent disputes between Jones, a chief restructuring officer appointed by the bankruptcy court to oversee Jones' company, another company that supplies the nutritional supplements Jones sells on his show. According to lawyers in the bankruptcy case, Jones made disparaging comments about the restructuring officer over the weekend, one of the lawyers said. Well, anyhow, I'm going to try to keep following this, not in great detail, but I do think it's an interesting story to see how this thing develops. But I will tell you that people tell you what they're all about all the time. And if indeed their efforts are here to try and shut him down, if that's what this is all about, they're telling you that this was never about collecting the money, because no one would do that. There's no juice in that. There's zero juice in that. If anything, you would haggle with him and say, okay, look, we won't make you go through the whole process of shutting us down, but we want to get $200,000 for you towards this satisfaction over the next month. You know, you just sort of start trying to squeeze that way. Maybe get 100,000. Executing judgments is very challenging, though. I'll tell you this: if they want to get his money, it's very challenging. If he's in bankruptcy, they can't do anything about it while it's in bankruptcy. Anyhow, so that's the story with Alex Jones. Just wanted to keep you all updated on that. The newest president of Mexico is a non-observant Jew. I don't care. I really thought about yesterday's stream. Oh, thank you. That's why you said you have shovels, because you were thinking about Pisco? King of recruitment, Master Phillips. Whoops, that's not the right one. Hitting up with 10. Count them, 10. I said 10. That's the number I said. 10 good Lawgic memberships. Let's see who we brought into the fold. The king of recruitment. The king of recruitment. Gifting those memberships upon W. Daisy Girl Williams, JD, Uncle Bob's Bees, Warren Moffat, Morgan, Kathy Weirley, Dirk from Texas, Sarah Violet, Hoosier Flatley, and Barnabas Collins. All you guys, I hope gave your gratuities, thank you, and kudos to King of Recruitment, Master Phillips, who's dropping memberships on you all. Now, some of you might wonder, because some of the names there, I'll be frank with you, I don't really recognize. You might be new here, in which case I'm saying welcome to the following. The one place that everyone knows is not at all a cult type of cult, even though it's called the following, which I understand that does sound a little bit culty, even though we do have positions like leaders and disciples and prophets and high priests, depending on, people's commitment levels to the following. In no way, shape, or form is it a cult type of cult. There's no Kool-Aid, no spaceships, no self-harm, no harming others, no stabbing yourself with a jabby jab, no throwing virgins into volcanoes, no dancing around fire while shucking up clothing to the beat of a tom-tom in the middle of a forest, no squirrel mutilations, no goat sacrifices. There's really only mild farm work, no tracksuits that are mandatory, and people just say, why would anyone think that's a cult? Type of cult. It's just about personal growth. Spell it with me: community, unity, and leadership training. Self-embetterment. That's what it's about. Feel the self-embetterment. It's enriching. Okay. That's what I want to. So welcome all of you there. Between Two Ferns, so supplemental. Nice. Oh, new member of the following. Member for 1 month. Joe, none of the families say they went to court to get Alex's money. So if that's, then why they get so much of it? We're not here to get his money. We just demand a really crazy judgment. And if they're not there for the money, then they shouldn't be there, because they don't have the relief of having the right to shut down someone's First Amendment rights. So, hey, Joe, I just want to say I appreciate that you're able to objectively consider opposing views, even when they're wrong. Keep up the great work, Joe. And if there's ever an opposing view to me, it's wrong. See, this is what I've come to realize. It's invariably wrong. Sometimes, once in a while, it's not. Once in a while, I learn something new. But yeah, so if I'm only going to tolerate right views, I'll just end up talking to myself all day long. That'd be kind of boring. So I appreciate I appreciate your recognition of my efforts to try and, all kidding aside, to try and reach across the aisle and hear from other folks. Ruby Ridge seems ridiculous until people died. I don't know enough about that story. This isn't the AJ stuff about free speech. Isn't it about free speech? I guess. Yeah. I mean, that's why they're trying to silence him, right? But look, it's always like if you understand the system, you can sort of use the system appropriately. So if you understand the system, let's say, and your objective is to shut him down, you know you can shut down his studio because it's technically trying to get his assets and auction them off for purposes of trying to settle your settlement. So you sort of can use the system as a window dressing for what your actual to mask what your actual agenda is. So important. One of the things that gives people who are familiar with the system, and this is why people look to lawyers all the time, because we actually invest time in understanding how the rules of these games actually operate. I'll share with you an update on Nick Rekieta that happened today, which would not have happened if which was a great benefit to him. It was a big win for him. And it's not even a win. It's not even, I would be loath to call it a win. But it's a development that's positive for him, which is, different. No one can argue that it's positive. We know that we talked about how the judge who was randomly assigned to this case, the one who issued the warrant against him, was Judge Fisher, who apparently he had said some negative things about in the past. I have not heard those negative things. I've heard people make those statements that he had said negative things about her. And everyone was like, oh my God, he's going to have to go in front of this judge. He's going to have to go in front of this judge. Well, lo and behold, he don't. Lo and behold, that ain't the case. Lo and behold, things work out for him where he doesn't have to go in front of that judge any longer. He's no longer dealing with that judge. Why is that? Well, it's because Nicholas Rekieta, we're talking about knowing the rules of the area. Nick Rekieta here got an order in the state of Minnesota versus Nick Rekieta to the court administrator. He filed the above motion caption matter. He filed pursuant to Minnesota Rule of Criminal Procedure 2603, subdivision 14, subsection 4. Here, guy gives notice to remove the Honorable Jennifer Fisher from presiding on any further hearing or trial and requests another judge of this district to preside on all further litigation hereon. Respectfully submitted, Nicholas Rekieta. So that's what he filed. He's like, I don't want this judge. And under Rule 26.03, I'm asking you to change it. Give me a new judge. That's what he did. Show enough. Show enough. Ask and ye shall receive. Follows the same thing for Kayla. Why can't I get this? This is so annoying. Kayla Christine Rekieta, defending the above caption matter pursuant to Minnesota Rules of Criminal Procedure, Rule 2603, Subdivision 14.4, hereby gives notice to remove Honorable Jennifer Fisher. She, too, getting rid of or asking to have that judge removed. We look a little further at the procedure here as to like exactly what's happening here. And sure enough, state of Minnesota, ask and ye shall receive. What was if we look at that statute, what he was looking at there. So Rule 2603, Subdivision 14 says substitution of a judge. Notice to remove. A party may remove a judge assigned to preside a trial or hearing as follows. How do you do that? A notice to remove must be served in the opposing counsel and filed with district court within 7 days after the party receives notice of the name of the presiding judge of the trial or hearing. Notice must be filed before the state of the trial or hearing, and notice is not effective against the judge who already presided at the trial, omnibus hearing, or evidentiary hearing. If the removing party had noticed, the judge would preside at that hearing. So, accordingly, they say if you got in there and you haven't heard, it's not like you saw your judge and said, I don't like this guy. But before you had a chance to see that judge, you said, I don't like this guy. And you do it timely, meaning that you do it within 7 days. You simply need to ask, and it's granted. You get a new judge. In fact, that's what has happened now. Judge Fisher herself recognized that she had to remove herself. She signs off on the order. State of Minnesota versus Nicholas Robert Rekieta. The order request removal is granted based on timely filing of notice of removal. And Judge Fisher signing off on it, saying, I'm out of here. Not my case anymore. He timely asked to have me removed. I'm gone. Now, who's the new judge who came in here? New judge coming in on this case is, let's look. Judge Stephen Wenzel is now the case assigned to. All future hearings shall be scheduled before this judicial officer. Judge Stephen Wenzel. Please note that a notice to remove this judicial officer must comply in all adult criminal cases with Minnesota, and everything now is moved over to Judge Wenzel. So I actually asked Nick, do you know this guy? Because he didn't get to pick who the new person is. He can say, I don't want this judge. And then once he says, I don't want this judge, Minnesota says, okay, we'll give you Judge B. I got a feeling that's like basically they take her name out of the pot and then they go through the list of the other names and they pull that name out and they pulled out Judge Stephen Wenzel. I asked Nick whether he was happy with this judge. He said, yes, he was much happier with this judge. Much happier with this judge. So, I don't give you any more detail about that. But I didn't have it. It was actually just a text message where he said he was much happier with this judge. So, and he thinks that this judge is very fair. So that if you're pulling for Nick Rekieta to have success with his legal battles in Minnesota, which I know not everyone is for one reason or another, but if you are hoping that he's going to have success with respect to his legal battles, I'm sure he's feeling a lot better about who the judge is on this case, because as we see in the Trump case, who the judge is matters a lot. A lot. I'm going to get in on that very soon as to the issues that we've seen with judges over the last week or so. It really matters a lot. You wouldn't think it does, but it sure does. It sure does. What? Why are people punishing me? Why? 13th juror? Is that the name of a book? The judge of 13th juror? I'm not sure what that means. And he put the wrong county and district on that. I don't know who did. But I want to thank this guy, Nathan. He's the one who called this to my attention. Are you saying in his request he put the wrong county? I don't know. In the day it worked. 8th. What county and district? I'm not sure. I'm not sure who does what here. But anyway, bottom line is, thank you, Nathan, for calling that to my attention. Wellesley says, so is Worcestershire leader Aaron and Good Lawgic the leader? Leader Aaron and Good Lawgic the leader Moses. No, I'm not the leader. I said over, I don't know why this confuses. I said this over and over again. I'm not the leader. Pretty simple stuff. It's pretty simple stuff. Anyhow, so I was thinking about whether or not to go over stuff related to Rekieta. I said, you know what? I'm going to ask my poll. In the poll, I said, maybe I'll cover some Rekieta stuff. Maybe I won't. And I put up a poll where I said, what do you want me to cover on Rekieta? Should I spill the tea? You want me to spill the gossip? Gossip. You want just law, no gossip? Or are you done with it? Like, what are your thoughts on it? And I put up a poll. That's what I put in my poll. That's my poll. You want to see what the poll says? Let's look at the poll. We'll try to follow the poll as much as possible. Poll says, oh my God, you guys are evil. 68% saying spill the tea, any gossip. 22% say law stuff always, gossip, hell no. And 10% saying stop. I'm not doing the gossip, not really. I'm not doing the gossip, not really. But I am going to respond to Robert Burns because I was watching Soltron in my if you're not subscribed yet on goodlogic.locals.com. So that's my locals, goodlogic.locals.com. So a gentleman by the name of Soltron there shared a clip. Soltron shared a clip of Robert Barnes talking about his frustration with people in the Law 2 genre. And I'm well aware of the fact that he's gotten a lot of heat. He's gotten a lot of heat for his take on this. And I give him credit that he keeps blazing forward. I wanted to sort of hear what he had to say, let him break it down, and give you my feedback. I'm going to avoid talking about the drama elements of it, even when he talks about the drama elements of it, and fixate exclusively on the legal element of things here.
And then
So, seeing as you guys want me to cover the legal element of things, I'm not going to be doing the drama. That's just not how I roll. I leave that for other people who have no other way of creating content. I fell in heart with President Trump. Nice. The prick Aaron spoke your name talking. I don't know who Aaron is. Oh, Aaron Imholt? Oh, I'll forget his name 10 minutes from now also. So it doesn't really matter. Not really worried. I did not vote in the... Nice. All right. I'm just going to say this. Every once in a while, I'll see some I'll see some buzzing going on. You can spend your entire life just, SWAT, 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 SWAT. And then just they seem to multiply. So yeah, why even walk? Just move along. People are gonna do what they're gonna do.
in answer to Law 2, they don't understand retaliatory prosecution under the First Amendment. In fact, they seem that there's this guy, potentially criminal Sean. So
he's gonna hate on PC Sean for a moment here. I'm gonna skip past that because I thought that he was hitting a little low on that. So I'm going to skip past that part there.
That verse for referring to.
Well, that's who he is. I mean, he's a total loser.
All right. I didn't realize he was hitting on him that long.
People who love to hate and just nasty, nasty people. But he's making up the law as he goes along. They're not understanding the First Amendment. The First Amendment issue is selective retaliatory prosecution.
And I just want to point out that as a general rule, I tend to like everyone in this sphere. Like literally everyone. Almost.
He claims if you think judges could be corrupt or prosecutors could be corrupt or police, and this guy feigns as a criminal defense lawyer, or cops could ever tell a lie, then that means you're a crazy conspiracy theorist. That's how lunatic this guy is.
See, I don't think Sean actually said that. I think he basically was saying, if you think that everything's a lie, I think that's basically what he's saying. I do feel like look, whatever. I'm gonna move past this.
This guy has no business being a criminal defense lawyer. But retaliatory motive is all over the place as it concerns Rekieta involving the individual officers and jurists involved. The Second Amendment issue is pretty darn simple. Aside from the Second, Eighth Amendment issues of,
I'm just going to point out the reason this will be unavailing to the public is because if they went in there and found no drugs, then it feels like it's retaliatory. The reality is this. It's like there's like two different conversations that are happening here, okay? Because what Robert Barnes here is fixating on is Constitution and the law, and this is what the law is and how the law should be approached and things of that nature. But then in the court of public opinion, that's falling on very non-sympathetic ears, because if you took a completely different circumstance, right? A completely different circumstance where you have someone who, you know, is believed to have butchered countless people and they have bodies in the basement, and the police have a garbage search. They have a garbage search warrant. They just don't have a strong, or they have a very flimsy search warrant. They go in there and they find the bodies. So now, yeah, the constitutionalist is going to be like, what the hell is happening here? Because, you know, we can't allow the police to go in and just violate these search warrants. And it's like, and imagine not just bodies, imagine there's a couple of other people who are still alive down there. And they don't even know about the living people. Because when you're if they're living people who need to be rescued, that's an exigent circumstance. You wouldn't need a search warrant. But let's say they didn't know about that and they happened to save a couple of lives. When they went down there, when it got a search warrant, and while they're there, they find the lady in the well who's being chained down there. And you'd be like, what the heck is, so people will say to the lawyer, what the heck is wrong with you that you're sitting here fighting that the search warrant is unconstitutional, and you're sitting here saying, look at how they end up saving this woman's life and finding these other bodies and all this other stuff there. And that's what public perception invariably is going to be. That will be what public perception invariably will be. And over here, and by analogy, people say that, look, you know, they found the drugs. They said they thought they would find drugs, and they found drugs. So public perception is always going to be going against the position that Robert's taking. I will point this out. Here's where Robert is. The one area I'll tell you Robert is correct is I took this argument. I had this argument taking the basic PR side of things, the way people in the public, in the world opinion, court of public opinion perspective on a show on this channel 6 months, a year ago. And I was debating on behalf of but there's dead bodies down there. And I had 3 people yelling at me that I'm dead wrong on this. And arguing the constitutionalist position. I think one of them was Legal Vices. I'm not sure if he was one of them. I remember for sure that one of them was Andrew Branca. And the other one I remember for sure who was arguing that point was potentially Criminal Sean. And yelling at me that no, you can't just allow, because cops will make stuff up and cops are going to do whatever and they're going to make stuff up, make stuff up. Yelling at me until they actually convinced me. I was like, yeah, that basically the police state is the scariest thing. It's much scarier than some individual lunatic out there, or 1,000 individual lunatics out there, is having a police state basically trample our basic civil liberties. They sold me on that. They brought me into that. I was the one arguing the other side, the side which court of public opinion is on now in this particular saga, or at least not entire court, but a significant percentage of them. And who was the one yelling at me? The constitutionalist issue. It was Andrew Branca primarily, and Sean. So now I don't know why it is. I don't understand why it is that in this particular circumstance that Robert Barnes is the only one arguing here. Maybe someone could walk me through this. Maybe someone could walk me through it, because I don't understand it. I don't understand it. I don't get it. It doesn't make sense to me. Because these are two different things. This constitutionalist argument, think about it in the case of someone who's like, a homicidal maniac, and there's a flimsy warrant there. That everyone, all the criminal defense attorneys are always screaming that's terrible. That's the worst thing possible. Let's not have a police state. That's everyone's screaming at me. And so I was like, yeah, I guess that's true. They say if you let it happen, it will happen. If you don't fight vehemently against it, vigorously against it, it will happen. So everyone was yelling at me. They brought me to that. Maybe some of you can explain it to me because I'm confused. I don't understand it. I don't understand.
Bail not allowing you to take somebody's gun away as a condition of release when they haven't been convicted of a crime.
Now, again, I still say when I looked at that warrant, I'm like, I think that's enough there. And I think Rob Barnes is going to miss a very important point here, a fact point that he just seems to just miss over, which is a very significant point. We're going to come to that when he's talking about the Fourth Amendment issues as to why it is I think this warrant has legs. And it's a very important fact that was alleged in the affidavit of probable cause that he just flies right past.
And
I assume it's by accident. I assume he read it too quickly or something. I'm guessing.
The other Second Amendment issue, which apparently uncivil law. I mean, he puts on his little Texas hat on and he fancies himself a Second Amendment guy. I mean, he clearly just doesn't know basic Second Amendment law.
Robert Barnes is blowing people up tonight.
So for those folks out there, I mean, our audience knows you cannot charge as a crime merely having a gun in the possession of drugs. Merely having it. But by the way, it turned out when we got the information, all of the guns were locked up. They were either secure in his private bedroom or almost all of them were in safes. Gun safes.
And just to highlight the drug issue, they measured 26.67 grams, including packaging. Now, I've never done these drugs.
All of it, by the way, they also found in safes. So there's the suggestion that the little kids were sitting around and there's armed guns and there's drugs everywhere. Total lie. He was not ever accused by anybody of child abuse. The pastor reported and said, by the way, I want to emphasize there's never been any child abuse. None.
They said 0 reports of physical or sexual abuse. Zero.
People are libeling online. Saying that. So, but this guy's repeating those lies, this potentially criminal guy, doesn't understand the First Amendment. Second,
I think most people have been alleging neglect. I think most, and let's face it. I think that the reason the court of public opinion has come to this conclusion, the Nick haters have come to this conclusion, is because A, they hate him. B, they see a ton of drugs there. C, they've seen him, they've viewed the degeneracy of his show as I guess indicative of drug use. D, you have this other factor here with respect to that show that he had on Monday. And they come to conclusions as to what's happening with his kids, which I think is, and based on a couple of people making claims. Are those people legit? Maybe they are. I definitely think a wellness check made sense. That made a lot of sense. But the pastor did say that there was, the pastor said that there was definitely, no claim of abuse. But I'm not looking to excuse neglect. My point is, I think that there was an assumption of neglect based on these 4 people. And I know that I understand one of them was coming out to be his sister-in-law. Like I said, I think this deserves a wellness check. I'm certainly, if in fact there was neglect of any kind, I don't think that's excusable. But I think that there's conclusions that are being drawn from people. It's like that they're like, I know, these kids are like, they actually never shower, or like they never have like, he doesn't give them food or stuff like that. And that's the part which I'm like, I don't think any of us really know. I can't tell you that I know they're well cared for. I don't think you can tell me you know that they're not. That's just the reality of the situation right now. Is that I don't think any of us know. People are making assumptions. And I'll be fair. I think I probably have leaned toward making assumptions in his favor just based on what I know about him, which frankly are assumptions as well. I think at this point, with respect to any issues relating to his kids, I think everyone is just making assumptions on relatively little foundation. So
civil law doesn't understand the Second Amendment. You can't charge somebody with it. It is not a crime to own a gun. It is not a crime to own a gun and also have drugs. It is only a crime to, in public, within the Second Amendment, to while you're in public.
Now, this is an area of law which I will admit to you I know nothing about. Like as far as gun ownership, when you're also in possession of drugs. He's about to make some very strong claims here about how this charge itself is unconstitutional. This cannot be constitutional. That if there is such a statute, it is unconstitutional. The counterpoint that everyone's been making is like, this is a garden variety freaking drug bust. First offense, plead it out, get no jail time, hopefully, and get the help that you need. So you're completely clean. So you can actually be what we want you to be, which is a healthy family man, putting out phenomenal content, hopefully more law related.
Illegally intoxicated have a gun. That is the only thing the Second Amendment permits.
No,
It
I'll
does
just
not permit criminal prosecution like this law does, as applied in this context.
And I wish he would cite a case here to basically point this up. He mentions one thing. I don't remember. I don't know what that case is. I wish he would give us a citation for this, because I would love to see that.
That's the Second Amendment issue, and they can't seem to figure it out.
Well, I'll stop you there. And if anybody disagrees with that, as a matter of fact, they'll snip this and clip this and say Barnes is wrong. You cannot have drugs and a gun in the same house. I do have my questions with that, because you have guns and marijuana
being adjudicated in over a half dozen cases since Bruin. Remember, we discussed 3 of those cases. Remember the Oklahoma case where it was pot in a gun, and it brought the challenge.
But some people are saying pot was a lower level gun than
it doesn't matter what the crime, what drug it is. The court made clear all of these decisions, same pattern. Merely being illegally intoxicated, no matter what you're illegally intoxicated on, it is not grounds to take away your gun rights unless it's public. Merely having illegal products it is not grounds to take your gun away.
Barnes Blog Vices, who was neutral because there was too far attack of mine, said 40 minutes ago. Like I said, that part of the drama I don't have any interest in getting into. I understand that the public is going to be very enthralled by that part of the drama of like what's happening on social media between this creator versus that creator. I'm keeping out of that altogether. So, or different, things that this guy said about that guy. You can all glean how I feel about what is healthy response to this based on, I guess, how I'm acting right now on this, where I'm just like, I don't want to talk about it. It's like my opinion on it is not really any more significant than anyone else's opinion on what's proper way for someone to deal with this. I'm telling you right now, my MO has always been, and hopefully always will be, wherever possible, avoid the drama. Because when you say flimsy warrants in a hypothetical, they agree. But when a real life flimsy warrant is in front of their eyes, they can't see it at all. Yes, it's very hard. That's a great point you're making, Von Cobra. As far as like what we label a flimsy warrant. It's one thing to say it's a flimsy warrant. It's another to say, okay, is this a strong warrant versus a flimsy warrant? That's really everything, right? I mean, that's really everything. Great point, Von Cobra. Just finished your video with Pisco. Here's some money for your well-being. Thank you, Kami. I could use it. Let me check on the ghetto. Make sure you guys aren't. Let's see what's happening in the ghetto here. The argument between LawTube is a good example. Originalist, textualist, consequentialist interpretations of law between different LawTubers. Interesting. Certainly consequentialists, yeah, versus constitutionalists. Yeah. Well said there. Let's see.
Way or punish you for having a gun within the Second Amendment. You've got to have to use that gun in public while illegally intoxicated. That's what court after court after court is ruling, and yet these so-called law tubers can't even research basic law.
And you
see, I don't think there are Supreme Court laws issues. I don't think this is decided by the Supreme Court. I think what happened is we all have to remember that Bruin is a relatively young decision. What's it, a year old? So understanding gun rights post Bruin is still amorphous. I was talking about this yesterday, and I'll probably talk about this 1,000 more times during the life of this show. That knowing what the law is at some points, especially like when you have a new wrinkle that's thrown into the law and people trying to figure out how does this affect existing law, is, you know, it's a lot of guesswork. It's a lot of guesswork. And I think he is referencing cases that have not yet reached the Supreme Court. So as far as, you know, because the Bruin case was, from what I recall, primarily focusing on the ability to restrict access to guns and, you know, general locations in general. But now translating that into restricting it from a narcotics user is not completely, but it's definitely a different context. And then you have to see, okay, so now that Bruin is there, assuming it does affect that, how does that impact these different statutes, like the one we're dealing with, that Nick is dealing with in Minnesota? So does it overturn that? Does that make it unconstitutional? I don't know. I certainly don't want it to be like that. This is like what he spends the next 8 years of his life fighting over. Certainly not with the gun charge. Maybe they put that one aside. I don't think they can parse out the gun charge versus this part of it, though. Like I don't think that works, because ultimately all these charges can be folded into one. You would imagine, with respect to whatever punishment he's facing. Go for big boy. I'm curious as to why the statements from the reporting parties in the past were not released with the warrant application. I guarantee you they were interviewed prior to the application and warrant service. I'm going to he talks about this. I'm going to talk about that momentarily. I'm going to come back to your statement.
Use could involve the mere brandishing or the mere possession. So it's not like you have to use it
as
in
long
a
as
crime.
in public while intoxicated.
Okay.
Those are the other components. That's the only historically valid application of the Second Amendment in this circumstance.
Go for it.
Well, then we get to the Fourth Amendment, which they completely butcher. I mean, there's all these people in the Camelots of the world, the umbrella guys of the world, these other people who now think the Fourth Amendment is a really low standard because the idiots on LawTube have told them that, because Nate the lawyer has told them that, because Legal Mindset has told them that. And these are people who don't understand the Fourth Amendment to the Constitution of the United States, and they're frankly spreading fake news about the law. So to be clear, probable cause is a real standard. You can't search.
Robert, I'll read it because I can actually see it with the screen open. The right of the people to secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, not possible accusations of, supported by oath or affirmation, and particularly describing the place to be searched and the person or the thing. Robert, some people are saying, this is the argument. I'm going to swallow before I choke on my own tongue. The warrant was issued. Therefore, it's a lawful warrant, and anybody defying it is violating the law. That's the argument. I'm an idiot. I'm Canadian. How is that not a proper...
Well, they wouldn't be violating the warrant, but okay, go on.
Retort.
I mean, the problem with that is that it confuses what a prosecutor alleges with fact and what a judge determines with law. So to give you some examples of what the Minnesota Supreme Court and the United States Supreme Court have said, and the standard is identical in both jurisdictions, because the Supreme Court has said the Fourth Amendment applies to the states through the 14th Amendment,
Mm-hmm.
is here are the things that cannot be probable cause.
Okay.
It cannot be casual gossip. It
Okay.
cannot be general reputation.
Okay.
It is necessary, and here's how hearsay rules apply. For example, Supreme Court of the United States, Supreme Court of Minnesota, both have quoted and said this at various points. It is necessary to evolve analogous guidelines to hearsay rules employed in trial settings in the in setting the standard for hearsay in a probable cause setting. So these people saying, "Oh, Barnes, hearsay is always allowed, doesn't matter." You're lying. You're lying out there. This is a law tube lying about the Constitution because they want to grift off the issues concerning Nick Rekieta.
Now, I'm not going to say there ain't no grifting going on. I will say no one's trying to lie. People are trying to like figure out exactly how this applies in this context. So that part I take issue with. There's no one's sitting. Okay, like I said, for the most part, most of the names you mentioned there, I don't think are at all trying to grift. Most of the names. But and you brought this up as far as talking to the pastor. Let's understand the pastor spoke to the other folks. So really, what that would mean is not talking to the pastor, but the people, because the pastor's not the one who made these observations. It's the four other folks who made those observations who you would think that there's a duty, and I think Barnes would argue, there is a duty for them to go and talk to them and check out their veracity. I'm going to push back on Barnes in just a moment here on what he's saying here.
In fact, if you're using hearsay, here's what the Minnesota Supreme Court requires. Here's what the Supreme Court of the United States requires. There must be independent investigation that corroborates those facts. You must establish the veracity and reliability of the person giving you the hearsay.
Which would not be the pastor. It would be the individuals who observe this behavior. So this way you can get their statements. And it'd be analogous to hearsay because it wouldn't be in court under oath, but you would be hearing directly testimony, potential testimony that later would become testimony. This is like sort of out of court testimony from these individuals and hearing what they tell you as to what they saw. And that would establish overcoming these issues. And I will agree with Robert Barnes that the failure of the Minnesota police, the KNDOI police, to talk to those individuals does seem like a real failing. Is it fatal? We'll come to that in a moment.
You must also establish what the basis of their knowledge is.
Right.
There's a sequence of decisions that have repeated these principles again and again and again, none of which, by the way, is present in any adequate manner in the Nick Rekieta affidavit.
I agree with him on that part of it, but there's a critical element he's missing.
Now, here's one of my favorite Minnesota Supreme Court cases. Guess what they have said about whether or not you can search a home based on substantial evidence that someone is a user of drugs, not a dealer, a user. Guess what the Supreme Court of Minnesota has repeatedly stated?
I have no idea. I'm going to say immediate risk of harm to children.
Well, no, just the opposite. What they have said is you cannot search a home based on the fact that someone is a drug user. That there is no assumption or presumption that meets probable cause to say simply because someone is a drug user in the past that they then currently have drugs at the home. They said that's not an assumption you can reach. That because why? Because they knew cops would abuse this like crazy to raid people's homes based on simply the allegation of illegal drug use. They're saying the allegation of illegal drug use is never sufficient constitutionally to raid someone's home. And yet all of LawTube was too lazy or deliberately lied about the law to know that this is the Minnesota Supreme Court and the key leading decisions that it.
No, this is wrong. He's factually wrong here. There's a key fact he's missing here, which is there was a great deal of I shouldn't say great deal, but there was certainly significant reference to the fact that he has that the officer who was seeking to get probable cause took note of that stream that he had and that the stream and the evidence that he submitted to establish that the studio was in fact in Nick's house, the place that they wanted to search, and that what he saw. So now he becomes the person who's observing. And I understand it's online, and you can say maybe it's edited, and it's just a video. It definitely seems as if, I mean, anyone who's watching it looks. If you're watching Nick Rekieta when he's doing his show, I don't think any of us question whether he's actually in his house, at least to a probable cause standard. And all the different steps he took to verify that that was in his house. So it's not that he's just a user, but there's that he's a user that we're going to assume he has drugs. No, we actually see evidence of him using. It's not that I know he's a user. There's an evidence of him using inside his house yesterday or 2 days ago, which I haven't seen the case law that he's referencing there, but that's another step right there. That's another step there towards probable cause that you're going to find drugs in his house when there's a video of him live streaming from his basement where he's, got powder on his nose and looking like he's on narcotics. So I'm not questioning what he's saying here that, that a user, you can't just raid a user's home anytime you want, because cops would abuse that. But if they're live streaming evidence that they're using cocaine in the last 48 hours, that might change the parameters considerably. You would think it would. I don't know that's the case, but I would think my first gut instinct would be like it would. I certainly haven't researched this. But to just say that this is reliant on the hearsay. So, and now when you're looking at the totality of facts here and seeing, can you get this thing overturned? So when you throw that nugget to anchor all the stuff that the hearsay folk that they failed to check out, and arguably he's correct, they should have checked that out. But now you throw all that in together, and I would think that would be a little bit of a different wrinkle than just saying, oh, this guy, we know he's a user, so let's go raid his house. It's like, no, he's practically using on stream. It wasn't on camera there. Now I do want to point this out. What I want to point out is that I looked at that video several times. I'm not sure that I'm seeing powder on his nose. A lot of people say that it is powder on his nose. Maybe it is, maybe it isn't. I think I know what they're talking about when they say that, like, on the tip of his nose, it looks like there's something, and at the end he wipes. I don't know if it's a glare. I don't know if it's not. But I'm just trying to say, like, as far as establishing probable cause. So now you have someone who claims to be an expert in understanding behavior of a user. This is not just this is a user and we're going to just randomly raid him whenever we want. No, it's a guy who seems to be using live on stream. And that happened in the last 48 hours, not 6 months ago. So to assume that you might find drugs there, you would think that, I don't know, to me, that certainly sounds more than just hearsay. I think he's making some good points, but I think that key element is one that to just ignore that as being a significant factor. I don't think that's fair. And I think to be so harsh on his peers in this genre while he's ignoring that, I don't think it's appropriate. So I appreciate that he's adding legal context that others have not added, but yeah.
That said that I can quote case after case after case after case, quote after quote after quote after quote, that from the Minnesota Supreme Court and the Supreme Court of the United States.
By the way, I haven't seen the last 3 minutes of this yet, so I'm in virgin territory. I have no idea what he says in the last 3 minutes.
That supports my initial proposition that this search warrant fails to meet probable cause under the Fourth Amendment. And they've utterly failed basic principles of Fourth Amendment law. Failed to articulate what the standard is, failed to articulate how hearsay is applicable or inapplicable, failure to articulate whether social media gossip and church gossip can ever be the basis of a search warrant, failed to articulate that merely being a drug user in the past is not evidence of present possession in the home sufficient to give probable cause to search that home. So they violated one after the other, after the other, after the other, after the other, because what they gave was constitutionally illiterate, fake news legal advice from Law 2.
Oh,
and
my God.
It's sad.
Oh my God. Okay. That's
And pitiful and of what they have become. That I had hoped they would be a check on the fake news from institutional legal sources over the last half decade. They've become instead advertisers and propagandists for that fake news, and in ways that are going to require calling them out on a continuous basis.
I don't think that's a fair assessment of anything that's Nate or Uncivil have done. Whatever.
When they lie to people about the law and they defame our Constitution in the process.
Robert.locals.com.
One last addendum.
Go for it.
People can ask Legal Mindset, why did you move to a town that is world famous for child prostitution?
I thought you'd
It's
forget
kinda
about
odd. But the other thing is this. So I get what these people try to do is brigade your comment sections, brigade your chats.
All right, I don't need those things. I think that seemed like it was the end of his legal commentary, so I'm gonna cut that there. But yeah, I think that I think his assessments, and he's not the first person from this genre who I see has basically gone after other people in this sphere and tried to, and has attacked their credibility or I guess tried to it comes across like trying to stand on others. That my assessment is correct and your assessment is wrong. And therefore, I don't know that everyone else's assessment on this is inferior. I'll tell you right now, I think my assessment on this is perfect. That's why I give that assessment. If I thought I could perfect it more, that's what I would give you. That's not. There's the difference between standing up for your own assessment and saying, I stand by what I say. I might adjust it a little bit based on different input I get, and saying other folks suck. Which he's not the only person I've seen certainly draw that implication. And it's not necessary. It's more clickable, but it's not necessary. Anyway, did the airman answering his door with a firearm as a military trained in the use deserve it? No drugs, just answering the door armed. I don't know that story. It sounds like a tragedy. It sounds like the start of a tragic story. So, I'm not familiar with that one. Can we have piss going again so you can make him squirm like a dog? Loved yesterday. We're gonna get to stuff that I didn't know yesterday. I'm gonna share with you key information that most of us did not know. I'm an attorney and I've been covering the story for over a year. I didn't know this until today. That the judge made sure the jury had no chance of knowing, which literally changed the entire complexion of how anyone could deliberate this case. Changed the entire complexion. Let me get to chats and then we'll go into that. Hunter Biden goes and buys a gun while addicted to drugs. He gets charged. Nick bought guns, then became addicted to drugs. Someone square this for me. Not sticking for Hunter. It just seems crazy. Oh, there's a big difference. Because a lot of people end up using drugs. It's the point is that he lied. Is that he lied to get his guns. Not that I ever was a big fan of charging Biden for that. For lying for that, because I think that's petty. Like I think that you haven't seen me do much on the coverage of the Hunter Biden story, only because I think that that entire thing is really petty. And I understand people saying you need to do tit for tat, just to sort of lash back, but I haven't done much. I do think there's a difference. I don't think they're at all the same, because the point is, it's a crime. The one person is the method of obtaining a gun is a crime. Is engaging in a crime to get your hands on the gun, as opposed to someone having a gun and then later getting drugs. So that's the key difference, I think. Malcolm, this is a guy who I've seen on X. I want to share with you something. Police report states that the father hearsay claims that passed away viewing live stream footage of Rekieta wasted, unable to care for kids, and with white powder on his nose, evidence of drug use. And before I even saw this, you see that I brought that up. And just because, look, while he's on stream, I wouldn't expect him to be the primary caregiver for the kids while he's on stream. So, you know, I say something like that, everyone's like, sweep. It's like, I'm just trying to be real. Like, I wouldn't think that he would. I would hope that in general. Although I mean, I know that sometimes there's the whole he ends up dealing with kids sometimes when there's like an emergency. But yeah, I would assume that there are others in the house who are looking after the kids when he's doing a stream in general. But I think you're saying exactly what I was saying. That video footage, I think, is a significant nugget in helping them secure a warrant. And Barnes just blew right past it as if that wasn't there when it was. If it wasn't in the warrant, it was something that just the public knew, then okay, I understand his complaint. But it was expressly in the warrant. I'm gonna tell you this. I want to point out Malcolm was like bashing me as far as like sweeping up for Nick when he saw one of my streams, and then like I was like, well, or I think he expected where I was gonna go, and then he took it back. So he like called me out publicly, and then publicly like retracted it, and I can respect that because like I think some folks out there are coming at this story with an agenda, a preconceived agenda. And I think some folks out there are really looking for people to be fair in their coverage without gilding it either way. And I think that's what Malcolm's looking for. And that's what I'm trying to deliver. I may not be perfect at it, but that's my objective is to deliver. Can you tell Coke powder from a donut? Exactly. I think they're talking about his behavior also. I think they're talking about his behavior. It's like, okay, you see behavior that looks like a drug addict. Before he was arrested, I said, I've never seen Nick like that, look like that. I said, that's not the Nick I recognize. So there's a difference between convicting, beyond reasonable doubt and saying, what do you really think is happening here? Right? I mean, I agree with you. Should that video be evidence that he's committed a crime as far as like now we can convict the guy for that? No. Are we all going to pretend that that the first thought everyone has, assuming you can see powder there, that the first thought everyone has when they're seeing him look the way he's looking, and assuming that you can see powder on his nose, that you're going to say that your first assumption is that it's donut powder? I mean, it's sort of got to be like real, right? This is what it's a reasonable conclusion. Doesn't mean you throw him in prison because like, oh, look at this video, let's throw him in prison now. But it does mean like, as far as probable cause, yeah, I think it meets that standard. Now, perhaps, and again, I haven't researched this, perhaps police are precluded from using video evidence because you don't know the timing of it, you don't know when it was filmed, whatever. Maybe that's not, I don't know. But I would think it at least comes into totality of circumstances and is far more damning than a pastor heard from 4 nameless people that were never interviewed. I'm just telling you how it just feels to me. And the law tends to mirror how we feel about things. That doesn't mean that the law is how it feels to me. I'm just telling you it's frequent that the law will mirror how we tend to feel about things. What would have changed the parameters if witness saying they have seen drugs in the home? This is what I expect in the warrant. Yeah, that would change the parameters. That's true. That would be a slam dunk, right? Having seen the idiotic legal gymnastics of the last decade, I lean more to Barnes' position than away from his position. That's fair. Cop did not say how he viewed a deleted video. Oh, well, clips from that video were everywhere. I saw it after it was deleted. You can still find it, clips of it today. Once you realize Barnes is a rainmaker for his firm, his public insistence that magical con law arguments can get you out of anything make more sense. Fair enough. I did a stream on this from a perspective of a former user. Might be a white pill to those who think Nick is lost. Great coverage so far. Thank you. Well, thank you. I appreciate your support. Not only did the fraud known as Barnes accuse Legal Mindset of being an Adobe Acrobat file, he also claimed anyone not supporting Nick are the equivalent of the Yahtzees and Kai lynch mobs. The failure is exposed. So you agree with Barnes? That's what you're saying? You agree with Barnes? You gotta make yourself a little clearer, because I'm not sure which way you're going on this one, Patrick. I mean, you may be a little biased toward your own assessment. Possible. Possible, but that's only because I do so well at making them. It's fun to watch Hunter blow up his own deal. Oh, yeah. Joe, I tell you an X regarding NH testimony tomorrow. Steve McLaughlin had the guts to fight Andy, who goes on Wednesday. And should I know what NH is? Should I know what NH is? There seems to be this very strong assumption that I know what NH is. I'm Nikki Haley? What's she testifying about? Spuds, yeah, my entire chat is trying to figure out what the heck you're talking about here. Ninja Hunters, No Hamsters, New Hampshire, the New Holland truck. I don't know who Andy is. I don't know what's happening here. Nursing home. There's New Hampshire testimony tomorrow. Oh, that's Cuomo. Is that Cuomo? All right, that I'd like to check out, actually. I want to see them squirm. Not that anything's going to come out of it, but I'd love to see them squirm. Maybe I will watch that tomorrow. If Nick gets Warren quashed but not address public image of drug abuse, he will not make a large comeback. No Rush Limbaugh moment for him. Oh, I totally agree with you. Video clips are hearsay and should not be used. Your fingers got in the way. Send Twitter DM about Barnes. 100% not in Barnes. I was kidding. Did you really take me seriously when I was like, so wait, which side are you on? I was joking. There's a lot of people who are very strongly in one camp or another. A lot of people very, very strongly in one camp or another. On a brighter note, what are your plans for 100K? You're getting close. My K word. I don't really have plans yet. I was really thinking about doing like a 12-hour celebratory 1,000th stream, like with 100,000 question mark, because I would be crossing into 100,000 during the stream. I was really thinking about doing that. Like 1,000th. It's not really 1,000th stream because it includes all the uploads that I've ever done, but 1,000th video on YouTube. Because when I look at my thing here, I look at my stats. I saw I was like at 994 the other day. So I'm like, I don't know. I think I'm gonna hit it this week. So I was like, should I spend like 12 hours on Thursday and do like celebrating my 1,000th stream and maybe 100th subscriber and 100,000 subscriber? Like I was thinking about doing that. Maybe I'll do that. Maybe that'll push me over. But what an utter fail. Think about the risk is what an utter fail if I don't end up getting to 100,000 during the course of that stream. I'd be like, oh my God. That's like, I'll be like, that's it. My 1,000th and final video on YouTube. If I would do that and not get to 100,000, I would just be like, yeah, that would be a disaster. That'd be a disaster. So it's a ballsy move. It's a tough call. Let's go, Brandon! My assessment is all the Nick haters are mostly Fig Newtons upset with being in a box, especially during Pride Month. Cuomo Wednesday. Steve McLaughlin, Rensselaer County Executive tomorrow. Steve, defy King Andy. Oh, Andrew Cuomo. I have to be cryptic in super chats. Okay. All right. I'd rather see Andrew Cuomo. I want to see Andrew squirm. Police also cite evidence from Aaron M. Holte's stream where M. Holte says he did drugs with Rekieta in their house, which police confirm he was in. It was very confusing to me when I was reading that police report. I was very confused when they were talking about Aaron M. Holte being there and he's in the background. That he was, I think, yeah, he's walking in the background of the stream while it's going on. That part of it confused me. That part of the probable cause statement actually confused me. I was like, I don't know what he's even trying to say now. But potluck. I love seeing the corners of my mouth twitch micro smile while being sarcastic. When I'm like when I'm trying to keep a straight face, like what I was doing here with this. Like, so wait, which side are you on? Those micros? Those micros. It's amazing I ever win at poker. I'm waiting till you hit 100K so I can unsub to 99 and give you humility. That's a why I like that. I like that move a lot. I like that's bold. Since Biden's son's drug use will be front and center for the next 2 months, they need to find other prominent drug cases to lessen the impact. I don't think that the Bidens are like, let's go after Nick Rekieta so people stop talking about Hunter. There's a lot of conspiracies that I'm like, yeah, that makes sense to me. This one, Theophrastus, is a little bit not really swallowing that one. Not really swallowing that one. I'm not really sure I buy that one. It's like, oh no, everyone's talking about Hunter. Go after Nick. Go after Nick. Maybe not. Maybe not that. That's probably not. It's probably not what happened here. Also, I don't know if you talked about it already, but Dave Smith roasting Chris Cuomo for 3 hours was a beautiful catharsis. Oh, I didn't see that. I didn't even know about it. All right. Should we talk about Trump? Let's talk about Trump. Let's talk about Trump, baby. Let's talk about you and me. I want to give kudos to Brad Smith. Brad Smith. I still don't buy it. I still don't buy it. Let's talk about Brad Smith. He put out 2 threads. You're probably saying, who the heck is Brad Smith? Who the heck is Brad Smith? I'm sure he's gonna have immunity anyway. That's another reason I never really got into the whole Hunter Biden thing. I was like, let's not kid ourselves. He's got a pocket immunity that they want to try to hold back until after the election before they flash it, because it makes Joe look bad. But if your kid was facing federal charges and you were the president of the United States, you give him pardon too. I'm behind, but Coke goes in the nose, not on it. Okay, fair enough. All right. So, yesterday you probably heard me breaking down the unlawful means. Just to give you, in case you missed that stream, I'll give you the quick 60-second explanation here. as to the charges, the 34 convictions that were slapped down on Donald Trump last week. What the state established to the satisfaction of 12 New York jurors was that there was some unlawful means used by Donald Trump, meaning a crime used by Donald Trump, and it's any of a bunch of crimes. But one of these, at least, all 12 of them agreed that at least one of them was used for the purposes of winning the election. Breaking the law to win an election is violation of New York Election Law 17-152. And then after he did that, he tried concealing it with his books and records. And there were 34 different writings which were all designed to try and conceal his violation of 17-152. But it starts with there's got to be some sort of unlawful activity. And that was the part that was very amorphous. What law did he break? And yesterday I was focusing on mens rea and the failure of the court and the testimony to elicit any signs that Trump even knew a law was going to be broken to help him win the election. Whatever falsification, supposedly, whatever the checks that this is, he's really repaying a loan, and he's doing it not to repay a loan, or he's making it look like he's paying his lawyer when really he's just repaying a loan. You still need to have that first crime. And what's the first crime? And the court came up with 3 different possible crimes. One of them was a FECA violation, Federal Election Campaign Act violation. He said, you broke the Federal Election Campaign Act. Well, today I stumbled on Brad Smith. You might say to yourself, who's Brad Smith? Who's Brad Smith? Here's his bio. Brad Smith, father, law professor, former FEC commissioner, chairman, Institute for Free Speech, lover of liberty and dogs, evidence-based, #free speech. That is Brad Smith. There he is. Okay. That's Brad Smith. Mr. Smith, going to Washington. That's Brad Smith. But the key thing I want to point out to you, former FEC commissioner. So he's definitely going to know FEC law a hell of a lot better than I will. What does he say about the FECA violations? In case you forgot, what did they say about the FECA violations? This is from my marked up version of the jury charges. What did he tell him? What did he tell them? He said unlawful means under 17, unlawful means to win an election. They said in determining whether the defendant conspired to promote or prevent the election, you can find any unlawful means. It could be violations of FECA. That was the first one. What's a violation of FECA? Well, the first of the people's theories on unlawful means is this FECA violation. And it is that if an individual willfully makes contribution to any candidate with respect to any election or federal office, including the office of President of the United States, which exceeds a certain limit, and that limit is $2,700. So when he gave $130,000, that was a gift of more than $2,700. Even if it's a loan, it's a gift more than $2,700. And when he gave that he violated FECA by giving him so much money. That's a violation of FECA. That is a violation of FECA. Terms contribution expenditures, he explains here, is anything of value, including any purchase, payment, loan, or advance made by any person for the purpose of influencing an election. For the purpose of influencing an election. Under federal law, third parties' payment of candidates' expenses is deemed to be a contribution to the candidate, unless the payment would have been made irrespective of the candidacy. If the payment would have been made even in the absence of candidacy, the payment should not be treated as a contribution. That's the relevant part here. The rest of what he said there is kind of irrelevant. Now, so what does Brad Smith say about this? This is what he says about FECA violations. Let's take a stab. Falsifying business records under New York law is a misdemeanor unless done to hide a crime. Bragg says the crime was a violation of the Federal Election Campaign Act. Actually, to be fair, he says it's New York Election Law 17-152, unlawful means, but one of those unlawful means, he says, is this FECA, which we just read. Or of a New York statute making it illegal to influence an election by unlawful means. Okay, so he does throw that in there. But if the latter, what is the unlawful means? And again, that comes back to an alleged violation of FICA. So it comes down to FICA. There are two potential violations here. One is acceptance of an unlawful contribution by the campaign. The other is incorrect reporting of a contribution by the campaign. Okay. Either way, we have to have a campaign contribution. It's not FICA if there's no campaign contribution. That allegedly occurred when Cohen advanced money to pay the Stormy Daniels settlement. FICA defines contribution as any payment made for the purpose of influencing an election. 2016 max legal contribution was $2,700. This looks bad for Trump. It's pretty easy to conclude the payment was made to influence the election by buying Daniels' silence, right? And Cohen paid Daniels $130, way over the limit. Well, it's not so simple. This, again, is a former FEC commissioner. First, let's clear up something. Cohen just loaned the money. He was paid back and then some. So where some ask is the contribution. Let's assume that even being able to access the money for a year is worth more than $2,300, which, to be fair, if you would charge interest and he didn't charge him interest on it, if there would be an interest charge, people would charge interest of more than $2,300 on a $130,000 loan. That wouldn't be crazy. So there's $2,700. So where some ask is the contribution, but this is not a winner for Trump under the law. A contribution includes a loan unless made in the ordinary course of business, which this is not the ordinary course of business. It's not a normal thing for him to be loaning money to him. If it's a bank making a loan, that's ordinary course of business. A lawyer making a loan is outside the normal course of business. Still, so it sounds like at this point, he's still in trouble under FICA. But for context, note that there is no limit on how much Trump can contribute to his own campaign. By October 27, when Daniels was paid, Trump had already spent more than $60 million of his own money on the campaign. It would have been easy for him to toss in another $130,000. Now, back to the definition of contribution. If they bought Daniels' silence to influence an election, what the prosecution alleged, isn't that a contribution? And also a campaign expenditure, which mirrors the contribution definition? First, common sense. We know that a campaign expense is not literally any payment made for the purposes of influencing an election. And reading that statute that way would be way too broad. For example, in 1999, Bill and Hillary bought a house in New York. One reason they did so was that Hillary would run for U.S. Senate from New York. In other words, the expenditure was clearly done in part for the purpose of influencing an election. Is it a campaign expenditure under FICA? Of course not. It's common sense. How about if a would-be candidate pays a lawyer to seal old divorce records because he's afraid that, if revealed, they would be damaging to his candidacy? Campaign expense? No, clearly not, even though done for the purposes of influencing an election. You're paying a lawyer to do something for you. So even though it's for the purpose of that, that's not a campaign. It's not considered campaign contribution. Or suppose a business owner wants to settle pending lawsuits against his business before running for Congress. He thinks that the lawsuits are BS, but he's afraid the press will make a big deal out of the allegations. Can he pay the settlements with campaign funds? The answer obviously is no. You cannot use campaign funds, even though it's designed to ultimately help your campaign to settle off some sort of uncomfortable lawsuit you're dealing with. Even though there's no legal obligation to pay them, and the settlements will be paid specifically to influence an election, you can't say, well, I was trying to influence an election, that's why I did that. In fact, each of these examples, it'd be unlawful to make the payments with campaign funds. You'd be breaking the law if you use campaign funds for any of those. This is because FICA also prohibits using campaign funds for personal use. What is personal use? Under Federal Election Commission regulations, and the FEC has primary authority for interpreting the law, it is any obligation that would exist irrespective of the candidacy. Indeed, the FEC regulations make clear that a mixed motive doesn't make something a campaign expense. If the obligation would exist irrespective of the campaign, paying it with campaign funds is personal use and therefore illegal. Now that's if it's a mandatory. This, you can argue, is not mandatory. This is what the left would say. You don't have to pay it off. Certainly, Daniels used the campaign to pressure Trump and for the most money she could. The timing affecting the value of her allegations, but the obligation did not exist because Trump was a candidate. It predated his candidacy and was not created by him being a candidate. It was always there because, as you can tell, he certainly wouldn't want her exposing that. He was trying to get her to sign NDAs years earlier, before he ever was running for president. Let's use common sense. Is it a campaign expense to pay for a non-disclosure agreement for something arising out of events 10 years earlier and not caused by the act of being a candidate? Is paying a hush money a campaign expense? Duh, no. And we wouldn't want it to be. We don't want candidates using campaign funds to pay personal expenses, whether new clothes, a weight loss program, a gym membership purchase to help the candidate look better and therefore for the purposes of influencing an election. And certainly not to pay non-disclosure agreements to keep embarrassing info hidden. In summary, the purpose of influencing an election is an objective standard. The motive of the donor or spender doesn't matter. So what are expenditures? Paying campaign staff is a campaign expenditure. Buying ads for the candidate, paying fundraising costs, paying a campaign accountant, paying for polling, travel to campaign events. Basically, all the obligations you incur solely because you're campaigning for office. That's a campaign expense. The FEC's approach is consistent with the U.S. Supreme Court, has consistently held in every case since FECA was passed 50 years ago that its definitions of contribution expenditure must be objective, not subjective, to avoid being unconstitutionally vague. After all, considering any political act or communication could be considered a campaign contribution or expenditure, protesting Genocide Joe for Biden's Israel policy, that could have the purpose of influencing this fall's election. If an environmental group advocates for green energy policies, is that a campaign contribution? Doing so could shape views on the issue and how people vote this fall. That might even be its purpose. Campaign contribution, expenditure? So none of these things violate FECA, even though they are what we would normally call expenditures, and even though done for the purpose of influencing an election. Again, it's objective. But none of this went to the jury either as evidence or instructions. So they basically had no idea what the hell, how to assess whether or not this is an expenditure, because the jury instructions were crap, terrible, lousy, designed to make them get confused. I shouldn't say designed for that purpose, but inevitably that would confuse anyone. This is stuff I did not know when I went through those jury instructions. This is information that people need to understand when they're interpreting whether or not Michael Cohen's advance is now breaking the law. Instead, the jury heard only from Michael Cohen and the prosecutors who claimed this was clearly a violation of FECA. In a second thread, I'll explain why there's no FECA reporting violation. We're about to go there now. So I'm like, wow. How is it they don't know this? And if you think it's bad they don't know this, the second thread is worse. Worse, somehow. Worse. I think you're arguably right. It may be unconstitutional. I'd rather than find it's unconstitutional. That'd be a great way. You know what? Just gonna point this out. I'm gonna pause for a second here and covering the FECA stuff. Do you know what delicious irony it would be? Delicious irony it would be if Hunter's gun charge ends up broadening gun ownership rights. Oh, that would be amazing. Amazing. If this ended up broadening gun ownership rights. Saying you can't keep a drug user from owning a gun. That would be great. If you're his lawyers, you almost have to make the claim, and you can't make the claim. You're like, what the hell do I do with this? Imagine we win on a claim that this is a violation of his Second Amendment rights to not allow a drug user to possess a gun. You have to make the claim, and yet you can't, because imagine if it wins. The headlines that come out is Hunter Biden enables drug users to buy guns. Biden v. U.S. Oh, the headlines. Oh my God. That'd be great. Not as great as Jenny, who's awesome. Hello. Let's keep going. 100K, folks. Like and subscribe. Thanks, Joe. Thank you, Jenny. You're awesome. You're really awesome. People don't even know there's a cartoon. There's a whole cartoon which makes this point that Jenny's trying to make here. You gotta like and subscribe. Boom. Just boom. Just boom. Hit it. Does it look like me? Oh, he's not. No teeth. All right. No, we don't need that anymore. I think we covered that. Oops. Didn't mean to do that. Stupid question, but will this crap show of a court ruling make any legal precedents? No. In particular, anything that can be used against bad actors? No. Nope. No precedents. You don't get precedents from a trial court. It just doesn't happen. Nothing noticeable. Just came across something on X, totally off topic. But should Christian, Jews, and Muslims start suing public schools, stop this rainbow jihad BS? What's the theory? What's the theory? That you're treating that this whole pride thing is a violation of my religious freedoms? You gotta walk me through the theory a little bit more. Even Trump is 100% guilty. He lost New York in 2016, 59-36. I know it doesn't matter legally, but the left makes a big deal about the election influence. Well, the point is they won't be able to call him a felon in Virginia. They won't be able to call him a felon in all these different states where they think they can take him down. In Georgia. FICA matters. You tell him, Zach. I need you to help my son out with his case. Joe Brand. Hollywood mega lawyer paid off Hunter Biden's $2 million delinquent tax bill. Surprise, surprise. Surprise, surprise. All right. So we covered FICA and how if you have a mixed use, mixed benefit, you're not allowed to call a campaign contribution. Arguably, it would be a violation of law. If he called a campaign contribution, that could be violating his campaign usage, his campaign fund usage. That's first and foremost. But let's get into the reporting. Let's get into the whole reporting issue. Because when we looked at this reporting issue, what did they say? Let's talk about the reporting. Falsification of other business records. This is what I hit on yesterday. And I was talking about how there can't possibly be mens rea for all these different things. Because the second of people's ludicrous theories of unlawful means, which I'll define for you now, is falsification of other business records. A person is guilty of falsifying business records in the second degree, the intent to fraud. He or she makes cause of false business entry in the business records of an enterprise. The purpose is to determine whether falsifying business records in the second degree was an unlawful means used by a conspiracy. You have to look at the bank records, et cetera, et cetera. Let's hear him. Let's hear his explanation on that. Michael Cohen testified that Trump wanted to keep Daniels' allegations under wraps until after the election. So understand, what are they saying? They're saying that you're trying to win the election by keeping it under wraps. That's your goal here. Keep it under wraps. That's why why did he not report this? Oh, because he was trying to keep it from the public eye. That's why. He didn't want the public to know about it. If it would have been reported, everyone would have known he would have lost the election. So he's trying to win the election by hiding this entire thing. Prosecutors claim they therefore legally did not report the campaign expenditure, and by doing so intended to and did have the purpose of influencing election. That's what 17-152 is. You kept it under wraps so that you wouldn't be exposed because you were trying to win an election. And if it came out to the public, you would have lost. You were worried you would lose the election. Presidential campaigns file monthly reports with the Federal Election Commission, the FEC. This is, by the way, in case you came late, this author is a former FEC commissioner. So he understands how FEC laws work. He's a lawyer and a former FEC commissioner. And explaining, and this is the sort of thing that would have been helpful if the jury knew this. Oh, it's a monthly report. These are filed on the 20th of each month and cover expenditures and contributions for the prior month. So, in 2016, the September report was filed on September 20th and covered expenditures made in August. The October report was filed October 20, reporting expenditures made in September. But after the October monthly report, the schedule changes. 12 days before the election, campaigns file a pre-election report covering expenditures up to 20 days before the election. In 2016, the pre-election report was filed on October 27th, covering expenditures made only through October 19th. So the pre-election report, filed October 27th, is not covering expenditures through the 27th. It covers expenditures made through October 19th. The payment made to Daniels was made on October 27th. So the payment would not have been reported on the pre-election report. It wouldn't have been anywhere on the pre-election report. Meaning, if they had said, this is a campaign expenditure, giving porn star $130,000, part of our campaign expenditure, it would not have been in the report before the election. The next report is the post-election report. This covers expenditures made from 20 days before the election until 20 days after the election, and it's filed 10 days after that. So that was the first report that would have included any expenditure to Cohen, or I guess from Cohen to paying Daniels. First time it would have come up would have been 30 days after the election. In 2016, the post-election report was required to be filed on December 8th, 1 month after the election. So the prosecution's theory that Trump wanted to hide the expenditure until after the election makes no sense at all. Even if we assume incorrectly that it was a campaign expenditure, and he had to report it that way, it wouldn't have been reported until 30 days after the election. How is it helping him win the election to hide it? But again, none of this got to the jury, either through testimony or the judge's instructions. Judge didn't tell him anything about this. So as far as they knew, the reason that they did this whole machination type of thing was to try and cover up so that he could win the election in November. But no one would have heard about it until December 8th. Merchant was rather obviously biased here, but I'll give him the benefit of the doubt and say that he just thought he was thoroughly ignorant of campaign finance law and had no interest in boning up on it to properly instruct the jury. That's not my opinion. That's his opinion. There was no illegal contribution or expenditure made and no failure to report an expenditure. And even if we assume otherwise, the prosecutor's theory made no sense, suggesting no criminal intent. I'm not a criminal law guy, but I do know campaign finance law. The failure to properly instruct the jury on the law would seem to be reversible error. Hells yeah. This is something I had no knowledge about, even when I was covering this as recently as yesterday, that all the reporting that supposedly would have exposed him if he wasn't lying, all that reporting would have come in December after the election and could not possibly have come out before that. So there's no benefit in him lying. Zero benefit. Was the jury informed of any of that? Hell no. Not even a little bit. So they think, oh, you know why they're doing this whole thing here? Because he doesn't want the public to know he'll lose the election. So he's unlawfully trying to win the election. If you actually know factually how things played out, and this is where expert testimony would have helped. Expert testimony of Brad Smith. It's not telling them the law. It's just telling you factually how things work with respect to filing the FEC. They didn't let this guy testify. The refusal to let him testify on this. Because Merchant is like, it's my duty to tell them the law. That's true, but this is not even a law thing. This is factually how things work with respect to filing the FEC. So you can figure out factually, was there any benefit to Trump in trying to lie? When the only people who would have heard about it would have first heard about it a month after voting. This is unbelievable that Judge Merchant did not allow this testimony in. That is clearly reversible error. And then making it worse is not educating the jury about this factor, taking judicial notice of the fact that if he had timely reported this, it would not have come to anyone's attention until a month after the election. If he had regarded it as a campaign finance expense and timely reported it, the earliest anyone would have seen it would have been December 8th. That should have been judicial notice. So how are you coming to a conclusion? It should have been directed verdict without even sending to a jury. How could a jury come to a conclusion that there's a possibility of him trying to win an election by hiding payments that no one can possibly see until a month after the election? So gross. It is so gross. It is such an abuse of the law. This is such a travesty. It's a joke. This entire thing is a joke. And the joke is not on Trump. The joke is what this did to how people regard our judiciary. It's a travesty. Palestine versus Pride. That would be fun. That is going to be fun. Was testing my money. I appreciate you testing it. Pro tip, don't F porn stars and Playboy playmates while your wife is pregnant. What are you a pro at? What are you a pro at? I'm very curious. Maybe we could just say pro tip. Defense should have called this guy. Oh, wait, yeah, exactly. Even if it's in the report, would anyone notice it? Would just be reported as legal settlement. It wouldn't come out till December. How is that helping you win an election? Don't marry the foreign hoe that your best friend Jeffrey Epstein introduced you to? Is that... I don't even know what that means. So you're assuming someone who speaks 7 languages is a whore? Weird. You're not completely tilted. Not completely tilted. Still don't see how a personal check from personal account to a personal lawyer is a business record. DJT couldn't even sign business checks in 2017. I don't know. I'm just hanging out here hoping I get more pro tips. More pro times. The night time is the speculum time. What does that mean? Dano says, I wish this case was about actual pornography, not legal pornography. All right. Wah, wah, wah. All right. Well, my friends, it's getting to that time of evening again. We're coming to that time of evening. I see the clock is winding down. You can see the last shot before the buzzer. We are coming to that time of evening. It's 12:30. I know I started late. But I'm hitting my spot here. So I'm gonna remind you all. As I kind of wrap up here. At the end of the day, you don't get win by trying to make as many enemies as you can. There's no winning in life that way. That's not a win. It's not a win. Some people might try to make you think it's a win. It's not a win. Live, Zen, peace, others. You'll be happier. Trust me. This is not happiness. This is misery. This is the face of misery right here. You can tell from the zero used in place of an O. This is a face of misery. See, even when you're taking Marty McFly here, can't even get a smile out of that guy. This is the face of misery. Don't be like this. Be better than that. You can all be better than that. Even this guy can be better than that. Maybe one day he will be. Don't let anger, divisiveness consume you. Be happy. One way that you can make sure you stay happy is no matter what they tell you, no matter how they try to sell it. I don't know what that is. But no matter, playing pinball is one way to be happy. But another, no matter what they try to sell you, telling you, all of you, even this dude, don't eat the bugs. Just don't do it. Don't eat the bugs. If you don't want you to eat the bugs, don't eat the bugs. I thank you all for joining me. I'll be back here, God willing, tomorrow evening at 10 p.m., hopefully on time. Till then, my friends, take care of yourselves, look out for your loved ones, and as always, good night and Godspeed.